Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. I am Jay Cohen out of Orange County. Might be even literally. I'm not sure they'd even let me in the courthouse there anymore. We've got Judge Lambert out of Marion County. And then we are honored to have with us Judge Siegel out of Brevard County, who's sitting as an associate judge today. It's our honor and privilege to have him with us for these oral arguments. We are recording these on YouTube, so just keep that in mind. Many of you probably are aware that Judge Lambert has his own huge following on YouTube, so the rest of us just kind of try to stay out of his way. We've got the case of Comelco, unless I'm mispronouncing that, and Old Republic Surety versus Five Star Airport Alliance and Berkeley Regional Insurance Company, case number 19188. That's consolidated with case number 19412. Now, I have a 5-minute default on rebuttal. If you'd like something other than that, just let me know. We'll be glad to accommodate you. So that said, we're ready to proceed.
Good morning. May it please the court. My name is Dwayne Diker. I represent one of the Appalese Old Republic Surety Company, and my co-counsel here today, Ron Schertzer, was trial counsel and represents the Appalese Comelco as well as Old Republic. We would like to split our time this morning. I am going to address an issue relating only to the surety's liability as imposed by the JNOV motion. That's for ease of reference, it's actually argument section 1 and the initial, the answer, and the reply briefs. And Mr. Schertzer will address the other issues, and we're cognizant that we have to split our time accordingly, and we would like to reserve 5 minutes for rebuttal.
All right, and you'll take care of watching the clock in terms of splitting your time?
Yes, Your Honor.
All right, very good.
So after nearly a 3-week trial, the jury specifically found Old Republic did not breach the performance bond and awarded no damages against Old Republic. And nevertheless, Five Star moved forward and the circuit court granted a JNOV overturning that jury finding. And the circuit court entered a final judgment finding Comelco and Old Republic jointly and severally liable for the breach of contract damages totaling about $142,000 and reserving jurisdiction on costs and fees. Those fees have since been awarded and are also on appeal to this court in case 5D 202202. And I think this court could, since it is on appeal, could take judicial notice of that appeal and the attached judgment, which includes a $2.3 million award of fees and interest. And there's a cost award that will be appealed soon. So this $142,000 compensatory damage award has spawned something approaching $3 million in liability, which is why we are here today. I know this court,
good reason to be here.
I know this court is familiar with the standard of review for granting or for reviewing a JNOV. They are reviewed de novo, and of course, to the extent there are evidentiary issues, those have to be resolved in a light most favorable to the surety as a non-moving party. Interestingly, the circuit court here was very clear about their decision on his decision on the JNOV. It was decided as a matter of law based upon an interpretation of the performance bond as a contract. So I think the question that I'm addressing, this question is, and the standard review is pretty clear. If the performance bond as a matter of law actually required Five Star to undertake any unmet conditions precedent, then this court has to reverse the JNOV. And we would say that the bond clearly placed unmet conditions precedent on Old Republic's liability that the circuit court ignored, expressly ignored. I mean, they said they were ignoring them. The circuit court held that the performance bond in this case only requires that Comelco be in default and declared in default, and that Five Star had performed its obligations under the subcontract and nothing else. We believe that to be clearly an error just on the text of the bond. And I will be referring a lot to, if the court has ease of reference of the bond, the performance bond form. It's page 648 in the record. I also quoted the relevant parts on page 14 of the initial brief. It's the second half of that page, the operative language of the bond.
Well, for what it's worth to you, that is one of the drawbacks of, probably about the only drawback of Zoom, is that it makes it difficult to, access unless you had a separate, computer going on at the same time. So you can cite to those. I can tell you personally that I don't have the ability right now to pull that up.
Okay, well, and it is quoted in our brief for your ease of reference after the argument, but it's the operative language of the performance bond. We know that 5-Star elected to complete Comelco's work under the subcontract after declaring them in default. So that gave rise to a few conditions precedent. One is that the performance bond required 5-Star to give reasonable notice to the surety, to Old Republic, prior to undertaking completion of the work. It's right there in paragraph 2 of the bond. 5-Star or obligee, after reasonable notice to the surety, may arrange for the performance of the work. 5-Star failed to give any notice, no less reasonable notice, of its intention to complete Comelco's scope of work. And the circuit court acknowledged this evidence in its order, and that has to be construed in Old Republic's favor. So the circuit court's determination that the performance bond required nothing of 5-Star except to complete its obligation under the subcontract was incorrect. They had an obligation to provide reasonable notice before they undertook that work and expected to recover from Old Republic. And we think that in and of itself is enough to reverse the JNOV order. But there was another obligation too that was imposed. Under subparagraph 3 of the performance bond, Old Republic's potential liability doesn't arise unless the reasonable cost of completing the work exceeds the balances still owed on the subcontract, which makes sense, right? It only kicks in if they are out of pocket in those damages. Now, I will tell you, in the initial brief, I might have too loosely used the term implicit to describe 5-Star's obligation to provide contract balances. So that became a theme of the answer brief. I will tell you that I think, and I believe that our argument clearly reflects that obligation is not implicit, it's explicit in paragraph 3. There's nothing implicit about it. The surety doesn't have to pay anything unless the cost to complete exceed the contract balances. That's the linchpin of the surety's liability on this bond, and there can be no proper demand without disclosing that information. Old Republic repeatedly asked for it. The circuit court acknowledged there was evidence that 5-Star didn't comply. So we believe that on de novo review, this court can determine whether 5-Star had an obligation to provide subcontract balance information as a condition to recovery. And again, I just want to be clear, I'm not suggesting that the bond language is ambiguous. I'm not suggesting the court has to resort to parole evidence, nothing of the sort. I'm just looking at the plain language of paragraph 3. I think that a reasonable interpretation of that, which is entirely supported by the text, would say that 5-Star has an obligation to provide contract balance information to make any claim. The whole paragraph 3 is about contract balances. It's not a surprise. The contract balances are the key, whether the surety completes or whether the obligee completes. It's the biggest paragraph in the bond conditions that 5-Star just wants to ignore. They want to focus on the sentence before that says, whenever a principal shall be and declared by the obligee to be in default under subcontract, the obligee having performed obligee's obligations there under a colon, and they want to focus on everything before the colon and not anything after, which of course is not how English works, right?
That's called a colonoscopy.
Right. 5-Star, they cite to a bunch of cases that we agree with, like DCC contractors, that say that a court has to consider the language of the bond. When they were trying to make an argument that there should be no implicit duty, they kept saying you have to read the bond, and we agree with that. You do have to read the bond, but they say we don't have to reveal the contract balances. I think it's akin to saying you've breached the contract, or you may have breached the contract, but we won't tell you why or how, but we're going to hold you responsible for mitigating damages. We're going to charge you with all our fees and costs for having to sue you. And I think that this interpretation permits a sophisticated obligee like Five Star in a construction dispute to ignore the bond language, to withhold key information, to ignore requests from the surety, to prevent any sort of analysis or attempt to settle the bond claim, while also suing the surety for breach of the bond and ultimately collecting prevailing party attorney's fees in the millions of dollars. And I don't want to take too much more time, but there was a lot of talk about general principles of suretyship and what that means. And while it is generally true that a surety's liability is coextensive with that of its principal, the circuit court omitted the.
Uh-oh. All right, Justine, if you could stop the clock. We have appeared to have frozen Mr. Dacre. Why don't we try to give him a call and see what we can do.
You're assuming that's not part of his presentation right now.
I am assuming it's not part of this presentation.
Emphasis right there.
Yeah. He's out of Tampa. It might be, he might be preparing for the Super Bowl. I don't know. Looks like we've lost him completely.
I think he's intending to try and rejoin.
Okay. Yeah, we're trying to get hold of him now. Our IT people are calling him up. This doesn't happen often, but it does happen occasionally. If worse comes to worse, we probably can get him back on the phone. But let's give it a.
Any luck in getting back on? Okay. Okay. All right. He lost his internet connection, and he's giving it one more try. And if that doesn't work, he's going to phone back in.
Okay, that's great.
We can't blame it on the snowstorm.
Yeah, we can blame it on the wind.
True.
And cold. Yeah, we get very little sympathy from the people up north when we complain that it's not going to be out of the 50s today. They don't seem to find that to be very sympathetic.
Not many of us miss driving in the snow.
No.
I like driving in the snow.
It was the other people driving in the snow that used to concern me.
Yeah, I left before I drove, so I'm incapable of driving in snow.
It's a learned talent.
It is.
Especially when you go from a rear-wheel drive car to a front-wheel drive car.
Probably something that's unheard of when you talk to people down the south about putting on your snow tires or putting chains on your tires to drive in the winter. What? What does a snow tire look like?
Judge Torpy's road, leading out of his North Carolina property was called Suicide Slide. I don't think so. I don't think that was going to happen with me. All right, here we go. We might be getting a phone now.
Okay, I think I am connected again.
Okay, can you hear us all?
Yes, I think so. I apologize. I
No.
don't know what happened. My internet connection went out, and my neighbor next door is building a pool, so it could be connected.
All right. Well, unfortunately, your time's up. I'm just kidding. All right. We stopped the clock right where you left off. You're at 10:32. That the only disadvantage to you is you're not going to be able to see the clock. But you're at 10 and a half minutes left in your argument. I think you were getting to the point of kind of wrapping up your presentation, but feel free to get back into where you left off. Okay.
Sure. I just had just another minute or so before I turn over to Mr. Schertzer. I would just say that Old Republic would respectfully suggest that general principles of suretyship don't favor an outcome where the surety is literally forced into litigation with the effect, if not the intention, of consuming valuable judicial resources and amassing just an incredible amount of fees. This is not the very purpose of a surety bond, which is supposed to protect innocent obligees from increased costs of completing work of a defaulted contractor. A bond is not strict liability. It's not insurance policy. Calling someone a surety doesn't make them liable for everything that goes wrong on a project. You have to read the bond, and the surety's liability is defined by the language of that bond. And we believe that the current situation is a poorly presented bond claim at worst, and maybe, or at best, and maybe profiteering or some such other thing at worst. If this is the law in Florida, it will certainly have a chilling effect on sureties and result in an increase in surety bond premiums. It has to. This is not what sureties thought they were signing on for. So we would just say that any true consideration of time-honored principles of suretyship that were discussed a lot in the briefs would result in a reversal of the JNOV or reinstatement of the jury verdict, finding no liability for Old Republic under these sort of unusual and inexplicable circumstances. And I'll yield the rest of my time to Mr. Schertzer.
Mr. Diker, what about the finding of the trial judge that the subcontract became part of the surety and that 5-Star complied with all of the notice provisions of the subcontract?
Well, that's true, and we don't necessarily dispute that. But the problem is 5-Star and apparently the circuit court, they're focusing on the language contained in the subcontract, but ignoring the plain language of the bond itself. Yes, the subcontract is incorporated into the bond, and yes, the jury found that 5-Star met those notice requirements. We're not challenging the jury on that point, but looking at the subcontract isn't enough. 5-Star is suing on the bond. You can't ignore the clear language of the bond that requires reasonable notice. So I would say what I'm saying is that following the notice requirements of the subcontract is required, but it's not enough to trigger the surety's liability under the performance bond when there are other terms in the bond, by its express terms.
So those would be conjunctive requirements, the language of the bond plus the language of the subcontract, or would you have to resolve any discrepancies between the two?
Well, I think that, so the subcontract terms are incorporated in the bond. So if there was a discrepancy, I suppose it would have to be resolved. I don't think that there's a discrepancy in this instance.
And one other question, sir, is there any consequence to the fact that the liability of Old Republic was included in a jury verdict form where it appears that it was a matter of law as to whether or not they were liable?
Well, it's an interesting point, and the circuit judge did address whether or not, that could have or should have been objected to, at the time of the verdict form. I think that
I think it's somewhat of a mixed question. I think I would agree with, the holding in the Alumaglass case that settled that ultimately the interpretation of the bond as a contract is a matter of law for the court. But there can be, and I think in this case, the way the case is argued, there can be factual issues relating to notice and reasonableness of notice, right? That can be jury issues. Now, in this case, because it was all done at JNOV, to the extent there were jury issues, they were decided in Old Republic's favor, and the court, on review and standard review should honor that and find, those things in favor of the surety. But so I think it can be, and in this case, probably was a mixed question with some factual issues relating to the notice. But the ultimate question is a question of law for the court.
Thanks, sir.
All right, Mr. Scherzer,
Yes.
just to let you feel a little bit more comfortable, I'm going to add some additional time.
Okay, thank you.
So I know that, and
42 seconds is a little tight for the rest of the issues.
Right, and I'll give the appellee, additional time as well. This is a big case, it's an important case, and so it just seems appropriate. So if you want to go ahead and take 5 minutes for your argument, go ahead and do that, and then I'll give Mr. McCray an additional 5 minutes if he needs it as well. So go ahead, sir.
Okay, thank you, Judge Cohen. On the issue of remitter, following trial, Comelco moved for remitter based on the fact that the jury did not take into account the obligation to subtract any damages from the remaining contract balance, and only if the remaining contract balance was exceeded would damages be awardable. So it's the similar issue to the one you've just heard. So just as the failure by 5-Star to establish the remaining contract balance dooms the performance bond claim, it should similarly result in the award of remitter. The standard measure of damages for breach of a subcontract in Florida is the excess expended above and beyond the subcontract price. And that is supported by Chisholm Development Corp. Versus Intercoastal Sales and Services, as well as Hightower Geotechnical Services, Inc. Additionally, in this case, we have a specific subcontract provision, section 7.11, which states that after the work is completed by the subcontractor following a breach, the contractor will calculate the total expense and damage for the completed work. And if the total expense and damage are less than any unpaid balance due to the subcontractor, the excess will be paid by the contractor to the subcontractor. So the parties' agreement itself recognizes the standard measure of damages, which is if it winds up costing me more than I originally thought to perform this contract, I'm entitled to recover the excess costs following a subcontractor breach. If it doesn't wind up costing me more than I originally contracted for and expected, I'm not damaged. And that's the essential argument on the remitter. The numbers support the fact that the amount paid to Comelco was $1,106,934.67. The contract itself was around $59,000, $159,000 more than that, or $160,000 more than that. That amount, $1,106,000, is supported by the testimony of the corporate representative for 5-Star, Mr. Burnt, who on examination about how much was paid to Comelco said about $1,106,000 plus $500 or $600 more. The damages presented by the witnesses for 5-Star show that they spent $124,175. They then attempted to tack on 10% for overhead and 5% for profit, and that's the $142,801.57 number that was presented to the jury. We argue that you should not get overhead and profit because you've already accounted for overhead and profit when you entered into the subcontract initially and then entered into a contract with the general. So whatever overhead and profit is associated with the subcontract work would have already been paid by the delta between what the contractor was getting from the owner and what the contractor was paying to the subcontractor.
Is that assumed, or is that part of the record?
The number is part of the record. The amount of the general contract is, I believe, part of the record as well. We did not get into the specifics of the contract other than to point out that there was a change order awarded to Comelco for extra work and extra time that was never passed on to change order awarded to 5-Star that was for extra work and extra time that was issued by the Aviation Authority that was never passed on to Comelco. And that was one of the main contentions. Go ahead.
When you have these change orders that add to the scope of work, is it your suggestion that that the additional overhead and additional profit can't be awarded as to the extra scope of work?
If it's extra scope of work, then yes, the contractor would normally tack on overhead and profit. But remember, the argument here is this is what it costs to perform the base contract with Comelco that Comelco didn't perform after the termination. So that's not extra work. If it's extra work, then Comelco had no obligation to do it because they never got a change order to do extra work. And that's one of the arguments they make is, oh, we had deductive change orders, so we should be able to apply that to the contract balance. But they also had additive change orders, all of which were never signed because the parties could never agree it. And if there's not a signed change order, the contract agreement remains in effect. So it's the original contract balance that is going to apply. If you want to start applying unawarded change orders, the evidence clearly demonstrates that the total value of the change orders that 5-Star was willing to award, but Comelco was not willing to sign because they didn't account for extra work, was an additive number of approximately $17,000. I am run out of my 5 minutes, and I guess we'll have to rest on our briefs with respect to the issues related to jury instructions and the expert testimony.
All right. Mr. McCray?
Thank you, Judge. May it please the court. I'm Jim McCray, and I represent 5-Star Airport Alliance. I'll refer to them as 5-Star. The first issue that I'd like to address is the first issue that was raised and discussed by Mr. Diker. Once the jury returned a verdict that Comelco, the bond principal, was in breach, and 5-Star, the bond obligee, was not in breach, and that 5-Star had been damaged in the amount of $142,801.75.57. There's some discrepancies in some of the exhibits, but $142,000 in damages for the extra work costs of completing the subcontract after Comelco abandoned the project. It was a simple and required matter of law for the court to enter judgment against the surety. And that was the express holding in the Alumaglass case. And in the Alumaglass case, that was also a jury verdict where the principal was found liable and the surety was not by the jury. The court noted that, but said it was plain error and it was a matter of law. And the fact that it had originally been submitted to the jury was overridden by the plain error. The cases that lead up to that, you start out with the American Home versus Larkin, that a bond is a bond and a bond covers the damages that are in the bond. Then you move on to DCC Randall Mechanical case, because there are a lot of cases that are cited where bonds contain conditions precedent. Their argument is that this bond contained a condition precedent. It didn't. The DCC Randall Mechanical case was the same bond form as this bond, verbatim. And in the DCC Randall Mechanical, which is the 5th DCA 2001 case, court held you interpret the bond according to its terms, and it covers the damages that it covers, and you don't add conditions. They're asking you to add implied conditions. These cases hold that you don't. You interpret it. Then you get to.
Well, I think, Mr. Riker, that they backed off of that language.
Well, they've backed off that language, and but now they're faced with the language in the Dooley and Mack case that we cite, which expressly holds that when a performance bond, such as this one, incorporates the contract by reference, and the contract grants to the contractor alternative remedies, including the remedy of termination and the remedy of completing the work and holding the surety, expressly the surety and the contractor principal liable for those damages, that those terms govern. And so under all those principles, it was a matter of law that was required, because the factual findings by the jury that the principal, Camelco, was in default. 5 Star, the obligee, had performed all of its obligations. They were not in breach. And the damages were for the sticks and bricks cost of the additional labor and materials to complete the work. Those are damages that are expressly covered under the bond. So
was the damages just to complete the work or to correct some of Camelco's work?
it was to correct and complete Camelco's work. They had work that did not meet the code, and they had work that they refused to come back and perform. So it was a combination of both completion and correction of defective work.
If it was just completion, if Camelco just simply said, we're out of here, we're leaving Florida, we're not doing any more work, and then there was still $159,000 owed under the subcontract, and you guys were able to get it done for less, would you then not have any damages?
We would not have any damages.
Okay, so
That's a point of great contention.
because there's case law that would suggest that if you simply hired, another company B to finish the work and they did it cheaper, you guys aren't really out of pocket. In fact,
I
benefited by that, actually.
And I agree with those cases.
Okay.
That in order to establish damages, you have to establish costs in excess of the contract balance. Otherwise,
you presented evidence at trial. Your side presented evidence at trial that said, look, we've got over and above the cost to complete, we got to pay more money to fix it, and we want to recompense that because we're out of pocket for what Camelco did.
There was ample testimony by Mr. Burnt and Mr. Port that, number one, Camelco never finished their work.
Right.
There was an unpaid balance to finish on the very pay application 22R that they rely upon to establish their uncontested contract balance. It has $37,000 worth of unperformed work that they never did.
Well, would you agree that the surety should be entitled to documentation for the expenses involved?
Not as a condition to their liability, and not when they are defaulted. Their argument is that there's somehow some condition that at the time of the declaration of default, we were required to tell them a contract balance. The contract balance is a defined term in paragraph 3, and that's the contract balance at the end of completion and when all the work has been performed and all the change orders accounted for. There were also at trial two change orders that were prepared and issued by Camelco for a $47,000 deduct in their contract amount for work that was deleted, for which they had been paid, but for which they never issued a credit. That further diminishes the contract balance. And in our brief, we go through, it's a numbers game. They say take a contract amount of $2 million minus the $1.1 million that was paid, and you have this magic 159,000, that was totally in dispute. The only way that you could have figured that out was with a special verdict form, because there were countless change orders, credits, deducts, back charges that were at issue in this 3-week trial. We presented it was a 44-page special verdict form, change order by change order, credit by credit, from which we could now sit here and determine what the math was that the jury did. But the jury accepted the testimony by 2 of 5 Star's representatives that there was no contract balance and that $142,870 had been spent in excess of the contract balance after having completed the work, and that's what they awarded. I'd like to address the issue of notice. In their brief, they have 2 sections, one for an express condition precedent and one for the implied. They've now receded. There are no implied conditions, so I won't go into those. But the express condition that they mention is notice. And they want to say that 5 Star never gave notice. Well, in our brief, we have 2 trial exhibits, defense exhibits 168 and 169, and trial exhibits 434 and 435. Those were 2 letters written by 5 Star. The first one was dated September 24, 2014, and it put them on notice of a default and gave them a cure period. The second one was dated October 14th of 2014, and it put both the surety and Comelco on notice of the termination. And it's for them to say, and both of those letters were acknowledged by Lisa Frazier, who was the vice president of claims for the surety, that she had received those. At her testimony, which is in the transcript, in the record, in the transcript at page 3330, where she acknowledged having received both letters. And let me read from a paragraph in the second letter, which is the notice of termination. Accordingly, pursuant to Article 7.11 of the subcontract, Comelco is terminated for cause from this project, and 5 Star hereby elects to retain other forces to complete Comelco's non-conforming work. The very letter that they acknowledge that terminates the contract also places them on notice that the principal has elected to undertake the completion of the defaulted principal's work. That's all that's required under the bond. There's no further notice requirement, and it was given strictly in accordance with the terms of the contract. They had a pre-termination notice, an opportunity to cure. They refused it, and then they went
your
on.
argument right now is basically that second letter you're just referring to complies with that subparagraph 2 of the bond conditions that are 648 that's cited on page 14 of the initial brief.
Yes, that letter complies with paragraph 2.
Yeah.
That it notifies them of the bond obligee's intent to undertake performance. And the jury's verdict establishes all of the other conditions, and their damages are clearly within the scope of the bond. And under Dooley and Mack, even if there were, which there's not, but even if there were a bond condition, contrary to the terms of the subcontract remedies provision, the subcontract remedies provision would prevail. But we don't even have to reach that because the bond simply does not contain the notice requirement that they want to interpret. And every evidence at trial was that they did in fact get it. And I can't understand how they continue to maintain that no notice was given when clearly their own witness said that it was. And it's perhaps, and the testimony, back to the earlier question of, doesn't the surety have to get the information? 5-Star did upon completion of the work. Once the work was done and the change orders, et cetera, the project was complete, they did provide the $142,000. They provided all that information to the surety. Here's your bill.
And how much of that was for correction and how much of that was for completion?
It would be, it was not broken down. There were, it was not broken down. And the problem with the completion, jumping ahead, 5-Star also had their total damages that they were seeking were $788,000. The court had granted a directed verdict to $588,000, which was extended general conditions. And those costs would have been out-of-pocket costs also associated with the correction and completion of the work.
That's
But
that's your cross appeal, right?
That's our cross appeal. Now, on the remittitor argument, they're seeking a remittitor, which would essentially award them what they claim as retainage. But the very case that they rely on, Hightower, in Hightower, there was no remittitor. The result was not remittitor, and in Hightower, the court expressly held that there was no error below in the failure to award that subcontractor its retainage, because the contract was not completed, and therefore it was incumbent upon the subcontractor to have produced evidence of the reasonable value of its work or the costs that it had incurred in partial performance plus profit minus payments to date. Those were the measure of damages for the incomplete subcontractor. They didn't do that here. That's not the way they presented their case. So the remittitor, there's no basis for a remittitor. There, in theory, there could be a new trial on damages for 5-Star, but there's no basis in the record for remittitor. We go through the numbers game in our brief. They don't account for $37,000 worth of unperformed work that's on the face of the pay request that they rely upon, $47,000 in deductive change orders that they didn't, that they prepared and that were submitted to us and approved and accepted by GOA, but not calculated by them. So there's all kind of numbers games that are being played. But the proof and the evidence was that those were costs in excess of the contract balance to correct and repair non-conforming and incomplete work.
Or do you want to go ahead and address your cross appeal?
Well, first, I'd like, while we're on this subject, because I noticed in the brief, in the initial brief by Old Republic, in their subsequent briefs, and now in oral argument, this argument about profiteering and about the case. And I can only say, I don't think I've ever heard such an inappropriate plea for sympathy from such an undeserving party. 5-Star was not the plaintiff in this case. Comelco was. Comelco filed this action in 2013, almost a year before they were terminated. Comelco amended their complaint in 2016 to make a $2 million claim against 5-Star and its surety. Old Republic is a compensated surety with full rights of indemnity and collateral from its bond principal. And for them to accuse my client of profiteering and being motivated to collect prevailing party fees is inappropriate. part of our entitlement to fees was their unreasonable rejection of a proposal for settlement. It was not Five Star driving this bus and driving everyone to litigate. Old Republic had the full power of attorney under their GAI with their principal. They could have stopped this case at any time they wanted. On our cross appeal, and I want to make absolutely clear, the cross appeal is only contingent that if we're not asking for a new trial on damages, but that would be the remedy if there were an issue of that they want to now raise. That was not, there was no argument at trial about some undisputed contract balance. There was no evidence presented by them of an undisputed contract balance. There were no witness that said, here's an undisputed contract balance. They didn't want 159, they wanted $2 million. But if we were to be remanded, the only thing that should be remanded is for Five Star to be given an opportunity for a retrial on damages for its $588,000 that was inappropriately, a directed verdict was entered on by the court. It was not liquidated damages. The subcontract had a liquidated damage provision that said if GOA, the owner, assesses liquidated damages against us, we will pass them on to you. But it also had standard remedy clauses whereby if you delay the project and you cause us damages, we can recover those damages from you. And our extended general conditions claim was not delayed damages. It was not liquidated damages passed on from GOA because there were none. They were out-of-pocket expenses that if we are going back, we should be allowed to present that evidence to further establish Five Star's loss.
All right. Okay. Mr. Scherzer, let me go ahead and let you go next, since you got kind of the short end of the time on the first go around, and I'm going to let you, you can have rebuttal as to, the initial appeal, and then you can respond to the cross appeal if you'd like, but I'll let you go ahead and start.
Okay, thank you, Judge Cohen. Briefly on rebuttal. The issue of whether it's correction or completion, quite frankly, for the purposes of proving your damages, it doesn't matter. You have to establish what you spent. What they're trying to claim is that the testimony of their representative saying, oh, we used up the contract balance, without accounting for how they used up the contract balance, what they spent it on, and where the money goes, is not acceptable evidence to establish damages. They themselves recognize it when they start to challenge the pay application, and they misconstrued why we were submitting the pay applications. It wasn't to establish the percentage of work completion that was being estimated by the parties. It was, this is how much money we got. There are checks attached to these pay applications. We got $1,106,000 and some change. That's the number that was paid to Comelco. At the end of the day, the only number they put up of additional expenditures was $124,000. So whether it was correcting work that Comelco should have corrected, or it was completing work that Comelco never completed, when you add up the $1,106,000 and the $124,000 that they presented, it comes out to less than the contract balance. Now, if it's additional work, can you argue that maybe they should be entitled to 10% and 5% on additional work over and above because you had to correct it, and so it required more supervision because you supervised it the first time it went in? Maybe, but did they do that? Did they separate it out? They acknowledge right now, no, they didn't do that. They have no idea which portion of the money that they spent was on correction and which portion was on completion. Next, they talk about deductive change orders. Again, the change orders were never signed, and the change orders that they presented that they said should have been signed by Comelco wind up with an additive number of 17,000. They only want to talk about the deductions because it only benefits them to talk about the deductions. But in fact, there are deductions and additives, and none of them mean anything because they're not signed change orders. And if the parties don't agree to it, it's not a contractual obligation. With respect to unperformed work, what they're talking about is in that last pay application, over and above the $1,106,000, they wanted to do more work, which they claim was not performed by them. But again, if they had to spend money to do that $37,000 of work, they need to present evidence showing how they spent it. And the only evidence they presented was $126,000. Last, they say there's nothing about the contract balance. That's not true. In Comelco's case in chief, one of the elements of the $2 million damage was the remaining contract balance of $154 or $59,000. I don't know the exact number. So all these issues were presented before the court. They can't simply rely on somebody saying, oh, we spent the money to wipe out the contract balance.
Well, was there argument to the jury that you guys just left the job and they had to complete it? Or was there argument to the jury that there was defective work that we had to fix, as well as you guys not completing the job?
Their argument to the jury was that we did not perform adequately and we refused to come back and do punch list work, and we refused to participate in UL compliance work.
So you did not perform adequately, meaning they didn't think you did a good job and there was stuff that they needed to fix.
They claimed that they had to fix stuff that we did that was wrong, in addition to having to complete the work. But the numbers they presented were the $124,000 numbers. So, in order to avoid a windfall, the contractor has to establish that I spent more money than I was going to spend in the first place. They can't just say, well, we didn't like the way you did it, so we're not going to pay you anything for what you did. And it doesn't matter what it costs to complete it. You don't get any more money once we terminate you. And if we complete it for less, good for us, we get to keep that, but you still pay the cost of what we pay other people to complete your work. And that's not the way it works.
Was your claim against 5-Star for $2 million?
It was approximately $2 million recovery. I don't have the exact numbers, but yes, it was a $2 million amount. And that included significant delay damage portions.
Well, that would seem to indicate that, there's a lot more going on than simply completion of the contract term.
The main contention by Comelco in the case, which is not accepted by the jury, was that this scope of this work changed dramatically from the bid documents to what was performed through numerous revisions to the drawings. They argued that it was a design build contract and we shouldn't have expected complete drawings in the first place. The jury ultimately, I think, from the verdict, accepted their point of contention. Okay. One last point on the counterclaim. Just look at the two provisions of the counterclaim, which are 714.2 and 714.4. 714.2 says that they get $4,500 per day up through substantial completion for delays and $2,500 per day following substantial completion before final completion. It also says that they only get that if the aviation authority assesses it. 714.4 says if this contract does not call for liquidated damages, then we can recover actual damages. Contract calls for liquidated damages. They initially were in jeopardy of getting assessed liquidated damage by the aviation authority. They were able to resolve that after they filed their initial complaint. Their initial complaint talks about recovering the liquidated damages. What they're doing here is the classic, I'm going to use liquidated damages when I like it, and then if I don't like the liquidated damages, I'm going to use actual damages. The law is clear. You can't pick or choose. You go one or the other. You can say up front before anybody knows the specifics of what's going to happen that, there's a good possibility we're not going to be able to assess the actual damages.
All right, Mr. Schertz, I got to cut you off at this point because I'm going to let Mr. Dacre have a couple minutes and then, then let Mr. McRae have a response very briefly, but I've got effectively 6 minutes to get this done because we've got our next case at 11 o'clock. So
thank you,
Mr. Dacre.
Thank you, Judge. And thank you for accommodating us in this situation. I do appreciate it. First of all, I want to be clear that with regard to the talk of implied obligations, we are not at all, we stand on our arguments and our briefs. We are not at all withdrawing any arguments or changing our position. I was just explaining that the word implicit led to all sorts of arguments that were not intended. We are arguing that these are express conditions. Mr. McCrae was talking about Larkin, which is, a Florida Supreme Court case, and he said that Larkin says a bond is a bond. Well, that's not what Larkin says. What Larkin says is a bond is a contract. That's why we have to look at the language of the contract. Five Star, they want to just call us a surety and be done, like it's a blank check. It's not that they had an obligation to inform us of the contract balances per se, but they don't have a claim unless they have damages in excess. So how can they even make a demand while they're withholding that information? It put Old Republic in an impossible situation. And if there's a frustration being expressed on both sides, there are some equities here that they were put in a position where they were completely stonewalled in an attempt to resolve this claim. They weren't allowed access to the project. They weren't allowed to come in and inspect. They weren't given the contract balances so they could try and negotiate something long before litigation ever started. They were just put in an impossible position, which is why, the millions in dollars in fees is so stinging to them. I don't understand this argument. I guess Mr. McCrae says he doesn't understand my argument. I don't understand his argument as to why he doesn't think there's a notice requirement. It's right there in paragraph 2. I don't understand how he reads that out of the bond. The cases that we cite, the cases that he cites say you have to read the bond, right? The bond is a contract.
Well, I understood his argument, Mr. Daker, to be that they complied with the notice requirement, not that there wasn't one.
Well, his argument, to be clear, is that they complied with the subcontract requirements. I don't believe he's arguing that they complied with the bond requirement, but if they are, I do want to look at that. And I'm not sure, I think this may fall within the province of what the jury determined, and that this court should accept all inferences in favor of the surety. But if we look at those letters, there was the 7-day letter, and then the letter that was September 24, and then the following letter, October 14, and they were in the record, they were 18-9-26 and 18-9-28. And Five Star says we followed it to the letter, right? We gave notice. But if you really look at those letters, I think it's not as clear as they would suggest. The first letter says that Five Star will transfer the completion of the subcontract to Camelco's surety. Right? It doesn't say anything about hiring someone else to do the job. It says they'll transfer it to the surety.
Mr. Daker, I need you to wrap up your argument, sir.
Okay. And I just say the next letter simply says they're going to retain other forces. So to me, that's not clear. That could be the surety. That's a letter addressed to Camelco and not to the surety. So I would just say that Old Republic was in full compliance with the terms of the performance bond. We believe the jury verdict has to be reinstated to find no joint and several liability for the surety in the same way that the jury made that finding. It's supported by the bond.
Thank you, sir.
Thank you.
All right, Mr. McCrae, anything that you would like to add?
Yes. First, I guess we flip-flop now of implicit or express. We're now calling their implicit conditions express conditions, but they're not in the bond. They're unreasonable. They're not required. And the way to avoid a windfall is not to grant a remittiture. There's no basis for a remittiture. If the court is worried about a windfall, or if the evidence could indicate—
Really, your response should be as to your cross-claim.
It is on our cross appeal. It would be to order a new trial on damages, to reverse the directed verdict that excluded our damages of $588,000 from going to the jury, and let us put on that proof and let us fully explain all of the damages, the contract balances, and all the out-of-pockets that both Camelco and Old Republic are liable for.
All right, thank you, sir.
Thank you.
Now, for just an administrative matter, for the members of the panel, we'll conference this case at the conclusion of the next case, but we're going to need to conclude this oral argument. Thank you all for your presentation, Mr. Dacre. I'm sorry that you lost your internet, but I think it worked out. So we'll be in recess on this case and go right into the next case on our docket.